number 12, White versus Cuomo. Counsel, you may remain in your seats. We'll just wait and give our colleagues here a moment to leave the courtroom. Counsel?
Good afternoon, Your Honors. I'd like to reserve 2 minutes for rebuttal.
You may. And counsel, in order for us to invalidate an act of the legislature, the plaintiff has to establish the unconstitutionality of the act beyond a reasonable doubt, correct?
Yes, Your Honor.
So let's start there and tell us why hasn't the plaintiff met that burden?
Well, first, they have not shown beyond a reasonable doubt that these contests, fantasy sports contests, are chance-based as opposed to skill-based. In fact, the evidence is completely one-sided on the question of the skill-based nature of the activity. And I recognize from the first time this case was argued that there are other considerations in play, including policy judgments. We have historical anomalies. So it's not simply a matter of looking at a definition and plugging in that definition. And there are a number of policy reasons here why fantasy sports is distinguishable from sports betting. I mean, that's what the plaintiffs claim this activity is. Sports betting is a type of proposition bet. Someone makes an assertion about something that's going to happen in the world. Aaron Judge will hit a home run tonight. The Yankees will beat the Red Sox. That establishes a benchmark. You look to what happened in the real world. Did Aaron Judge hit a home run? Once you make that proposition, whether it proves true or not, is completely outside the control of the parties to the bet.
And therefore, that is gambling under the definition of the Constitution?
Yes, that's correct, because I believe that the understanding of gambling in 1894 included sports betting. That's why they're saying this is sports betting. This is a skill-based competition. The only proposition that someone who participates in one of these contests is asserting is, I can assemble a roster of players that will win the competition. And it is true that there are random variables in the real-world sporting events, contingent events, that inject an element of chance into the contest. But the participants in the contest influence, if not control, the outcome of the contest in which they participate. And Judge Rivera, that's why the relevant contest is the fantasy sports contest. Because the proposition establishes what's relevant. If the proposition...
But I think I asked you this when it was first argued. I'm still having difficulty really following this argument because, of course, and every casino has cameras around to check on this, there are people with a tremendous skill to be able to count cards. But no one says that poker or blackjack is not, if I bet, that's not betting in the sense of we think of it. So I'm still very confused about your argument. And of course, there's absolute chance there because it's fact in a casino, right? The croupier has got not just one set of cards, but several sets of cards. So it really takes a particular level of skill to count cards, but that's what casinos watch out for.
I will give the answer I gave last time. Poker, which is a card game, was considered to be a game of chance in 1894. It's a historical anomaly because if it came around today, there's plenty of evidence that you could view it as a skill-based competition. Fantasy sports is not a card game, and it is not a proposition bet. It is an activity in which the people who participate in it influence the outcome. The proposition bet, the Yankees will beat the Red Sox, that dictates the relevant activity as the real-world sporting event over which the bettors exercise no control. I can out-general manager you in a fantasy sports contest establishes that...
But what about all the algorithms that are used in sports? I mean, aren't there a bunch of algorithms to kind of say the likelihood of so-and-so, you know, getting a particular batting average, being successful? I mean, I'm a little bit, again, I'm having, it's a genuine question to you. I'm having difficulty following this because there are so many what we call games of chance, or that we realize involves some guesswork, also has a certain amount of skill attached to it. And sometimes that skill nowadays can be refined through the use of algorithms and computers and so forth, versus, as you say, poker in the olden days, maybe somebody could count the cards. So again, I'm just having difficulty genuinely trying to follow the argument.
Well, let me try. It's important to identify what is the relevant skill in a fantasy sports contest. Is it basically, it's exactly what a gambler does? And the answer is no. There is a difference between what a general manager does and what a skillful sports bettor does. They both have math skills. They both make some predictions in certain ways. But a general manager identifies undervalued players. That is the essential skill of a fantasy sports contest. They have to live within the confines, for example, of a salary cap. You cannot just pick an all-star team.
So can I stop you there and ask you, let me give you work with a concrete example. One of the things that I believe that you may participate through DFS on is NASCAR, right? I just went onto the DraftKings website, so if you don't know that, you can. Just take my representation, or treat it as hypothetical. There was a NASCAR event at the Los Angeles Coliseum last week called the Classic Coliseum. There was a $50,000 on DraftKings cap, called a salary cap, and you could pick however many drivers you want, but you couldn't spend more than the $50,000. And the drivers ranged between something like $2,000 at the low end up to $10,000 at the top. So you could pick out of the very best drivers, you might be able to pick 5 or 6. If you're willing to choose drivers who had lower amounts, you could have more drivers. The points were awarded 45 points if your driver finished first, and on down to 1 for 40th place, nothing after that. There were also quarters of a point awarded for each driver who led a lap, and there was, I believe, 0.45 of a point for best time, which I couldn't understand if that was on a lap time for every lap of the race or how that was actually awarded. But why isn't that a prop bet? Why isn't that just like a daily double or a trifecta or something like that at a horse track?
Your Honor, it may very well be that that particular fantasy sports contest is indistinguishable from a proposition bet. This is a facial challenge. There are plenty of fantasy sports contests that are not like the one Your Honor described, that do simulate general managers of sports teams. So that contest may ultimately be found by the Gaming Commission to not qualify.
But a fundamental difference between what the general managers do is they're assembling players who play with each other and have to interact. And that's not true for the daily fantasy sports, right?
There are some features that differ, but a skillful fantasy sports contestant does have to make interrelated decisions. The amount of money you spend on your quarterback affects the amount of money you have available to spend on other players, just like a general manager who has to operate within a salary cap.
Or just like a horse track bettor who has $100 at the track, and if he spends it all in the first race, he's not going to have money for the second race.
The fantasy sports contestant also has to manage their team. Many of these contests have bench players. You can make trades. You live within salary caps. You have a draft. This is a simulation, not a duplication. And the fact that you can point to
I thought that the record on this reflected that the DFS didn't actually allow for trades. You lock in whatever the lineup is as of a deadline, and that was it. It was distinguished, I believe, from the season-long or month-long types of competitions. Is that wrong?
Yes, that's true, but some competitions you do have bench players. In some competitions you do make trades. In the daily you have either a salary cap, sometimes you have a draft, and since this is a facial challenge, it's the plaintiff's burden to show that none of these competitions can qualify as a skill-based competition. There are analogies one can draw to proposition betting, but the fact remains that you don't control in any way what happens in a proposition bet, but when you enter a contest that is determined by skill, it necessarily follows that your skill is influencing the outcome of that contest. Just like a fishing contest, It's a future contingent event beyond anyone's control, whether the fish are biting that day.
But isn't
or you're-
isn't the skill really the combination of proposition bets?
No, Your
Isn't
Honor.
that the skill you're describing?
It's the assembly of a team and the management of the team in many ways that are very much like what a general manager does. The decisions that you make are related to each other. And keep in mind, this is not, I think what Your Honor might be alluding to, this is not a fantasy sports betting contest, which would be a much tougher call. If it was a contest of, say, look at the 10 football games this weekend, pick the winners of all of them, whoever picks the most winners wins the contest, or decide which receivers will catch the most catches. If in that type of scenario, you are making wagers or estimates of what's going to happen in real-world sporting events and the actual performance of individual players. And that presents corruption concerns, just like sports betting, because if I'm betting you that Aaron Judge will hit a home run tonight, you can pay Aaron Judge not to play well and win the bet. It is almost impossible to fix a fantasy sports contest. So that's a policy reason to treat this activity differently.
So if I'm understanding this line of argumentation, your point is because although it depends on some reality in the world, it's a simulation, which is another way of saying it's make-believe. They're not really betting. But people are paying money and they're losing money and they're winning money based on exactly this world that they create, this simulation. So again, I'm hard-pressed to see how it isn't covered or prohibited, I should say, by the Constitution.
Well,
The fact that there's some simulation in it, that's like handicapping. I mean, I'm not sure I understand.
Well, the fact that it is a fantasy is actually a feature in favor of treating this as a skill-based competition, because you are not wagering on the outcome of any particular sporting event. If the Bills beat the Chiefs, it doesn't matter. You are not wagering that Stephon Diggs is going to catch any particular number of catches. It is a separate, distinct contest that has been created in which you exercise general manager-like skills, and there's evidence that that skill-based activity determines or influences the outcome of the contest. It doesn't present corruption concerns. That's why it's rational to distinguish it from proposition betting or sports betting. If you had a video game, skill-based video game contest, the fact that it is a fantasy makes no difference. I mean, after all, chess is a fantasy battle between two feudal kingdoms. That's an irrelevance. To the extent that all the fantasy nature of this is relevant, it helps my case because it's a creation of a separate activity that happens to derive information from real-world events. Admittedly, there's some chance element in that, but the skillful player realizes that and is able to make adjustments based on that. And getting back to the Chief's question, what evidence is there that this is a chance-based activity? Not a single study is cited by the other side. There's no discussion in their papers anywhere about why this cannot be viewed rationally as a skill-based competition, like a fishing competition, which also hinges on contingent events outside the control of the participant. Admittedly, this is a close question, and that's a reason to uphold the statute. If there are competitions that could be viewed as skill-based, it doesn't matter that someone can identify a kind of weirdly constructed NASCAR competition that looks like proposition betting. If this point is debatable, that's a reason to uphold the statute. And I know we always tend to cite the burden of proof and the standard of review at the beginning of your brief, and then you forget about it. This is a case where it really matters. The Supreme Court of Illinois found that these types of contests are skill-based contests. Half the states in the country have legalized them as skill-based contests, including New Jersey and Maryland that have constitutional prohibitions on gambling. I think the fact that this case is being re-argued shows that it's a close question. So if reasonable minds can differ on the proper classification, which is something more than just looking at definitions and plugging them in, I think the legislature's judgment is entitled to deference and respect. I know we had discussed what is the role of the legislature here, and I know it's kind of odd because I admit that this constitutional provision is a check or a limitation on what the legislature can do, but you have an express textual grant of authority to the legislature to implement the gambling prohibition. That's not simply a matter of attaching penalties to gambling activities, because you have to decide in the first instance whether a new activity is gambling or not. The limitation on the legislature, I submit, is that the legislature cannot authorize an activity that is predominantly determined by chance. This activity, it is conceded, is predominantly determined by skill, to a degree that skill predominates between 96% of the time and 65% of the time. Other lawful activities like commodities trading and the like are determined more by chance than fantasy sports. So even if this material degree standard applies, and it doesn't for the reasons set forth in my brief, it's rational for the legislature to find that these activities are not determined to a material degree by chance. I'll save my remaining time for rebuttal. Thank you.
Thank you, counsel. Counsel?
Thank you, Your Honors. Jeffrey Sharon for the respondents. Your Honors, the legislature...
Counsel, I have just right off the bat, when going through your papers, you argue that this court should not defer to the legislature's determination of the factual question of whether a fantasy sport contest is dominated by skill rather than by chance. However, when I reviewed your motion for summary judgment, you provided very little evidence, in my opinion, to the contrary. So regardless of deference, why shouldn't this court find and rule that you failed to meet your burden of establishing invalidity beyond a reasonable doubt?
Well, several things. First, as far as the reasonable doubt is concerned, this is not a factual case. This is not where there was a trial and one had to prove beyond a reasonable doubt guilt or innocence, et cetera.
So is there a different test we should be using then?
Yes. First, let me start and get to the deference. The legislature has no more authority to define the term gambling as used in the Bill of Rights of the Constitution than it has to define the term speech. And if the legislature were to say that certain internet-based content is not speech, that is not binding at all on the court, nor does that legislative determination deserve any deference, because the legislature acted outside of its authority in defining a term in the Constitution.
So we agree we define the term. What do we use to guide us?
So I think, Judge, that first of all, the test is what the common sense meaning is. And it's for the court to decide, not the legislature. In arriving at the common sense, meaning the court can apply a test, and there have been two tests that have been enunciated. One is the dominant theory test, and the other is the materiality test, which has been in the penal law for 65 or 55 years, and which has served its purpose. Materiality is a term that this court, or a test the court applies every day in all across the state. Materiality is always a question that courts deal with and are able to handle. Dominant theory, dominant theory is different. What does it mean? Dominant 51% from a quantitative standpoint, from a qualitative standpoint. If there are 7 participants, and wouldn't it be the possibility or the probability that one skill, if this is skill, dominates by 51%, but it might be 48% for another person, 3% for another person, 75%.
Can I stop you there for a minute? So are you saying we should not be concerned with what the people who implemented the constitutional provision thought they were doing? Should we care about that legislative history or no?
So, interestingly, yes, to the extent we want to look at what a legislature determined or considered to be gambling.
Well, really, the Constitutional Convention. That's what I'm asking
So you
about.
go back to that legislature, and that legislature in 1895, when they first, enacted penal law,
No, I'm sorry, I'm not asking about the penal law. I'm asking, we're not trying to decide the meaning of the penal law here, right?
no, correct.
We're trying to decide the meaning of a provision in the New York State Constitution,
But
a
the,
provision that was implemented in a constitutional convention.
and the legislature at that time determined that contests of skill or endurance of man or beast is what skill is. But if you're betting on contests of skill or endurance of man or beast, that's gambling.
I'm trying to ask you a prefatory question, which is simply, I'm not asking what they thought. I'm asking, should we care about what the people who put this provision in the Constitution thought?
Yes, Your
Okay,
Honor.
that's all I was asking.
Yes, I do think you should. And we should think in terms of how society and the opportunities to bet or gamble have evolved over 100 years or more, because obviously what is there and available today was not there and available then. Sports betting was recognized as gambling then, and this is sports betting. The fact that you're putting together a team that doesn't really exist doesn't mean it's not sports betting. You're still betting on the outcome of those people's production. And to distinguish, for example, the general manager is a participant. The general manager has control over the team. The general manager, as Your Honor pointed out, thinks how this player will work with this player, or how well they'll play together. Do I need one if I have the other? Is my relief pitcher going to be, sufficient against right-handed, batters versus left-handed batters? Your fantasy participant doesn't do any of that. He selects his team, and then he has no control over how that team actually performs in real life.
But counsel, there's a lot of activities that take place in the world that involve, aggregating probabilistic outcomes of future events that nobody knows what's going to happen. But, people do it all the time, and some people do it, and they make really good livings doing it, and it's quite legal. You can do it with securities, you can do it with real estate, you can do it with commodities. I mean, that can't be what the definition of gambling is, because then a lot of things that happened in the world would be gambling.
So this came up in the first argument.
It did.
And there's a very major difference between what's going on here and investing in the stock market, for example. When you invest in the stock market, you're not gambling, you are purchasing, you're investing your money, you're purchasing a proprietary interest in an entity or a fund, and people have to do something with their money. They can put it under their mattress, they can put it in a bank, they can buy stocks. They are making judgments as to, whether their money will increase or not. But they buy a proprietary interest, and they could hold it for 30 years or 40 years. They don't give it up. They can, but they don't necessarily give it up the next day.
But counsel, what I'm talking about is someone like a fund manager who puts together these baskets of whatever it is that you're, pardon the expression, betting on will happen in the future. And some people are really good at doing that, and they become very successful. And other people who are not so expert at it, who don't really know how to put together a nice basket of probabilities, they don't do good. And I think that's sort of what I'm hearing from the other side here, that there are people who are going to excel at this because they have the right skill set for doing it, and there will be other people, probably lots of other people, who aren't going to do well at it. But that's indicative that skill is involved.
But that's their job. And people rely upon them to make life decisions as to what to do with their money or their property. That's their job. They're not betting. No one has the job of betting on fantasy sports, whether it's daily or it's year.
Well, if you do it well enough, maybe you can make a living off of it.
You might, and more likely you won't.
Counselor, can I ask you a question?
Of course.
Regardless of the definition of gambling that we decide to adopt, do we have the authority, can we disturb the legislature's conclusion if we determine that it did have a rational basis for determining that IFS was or wasn't gambling?
Yeah, I respectfully submit, Your Honor, that this is not a rational basis test. Rational basis has nothing to do with this. This isn't a question of what evidence did the legislature consider, did they have the right witnesses, did they ask the right questions, were all the things that would go into a factual determination for a rational basis argument. Rational basis is, generally speaking, an administrative agency determination. This is not an Article 78 proceeding. So yes, you absolutely have the power to disturb the legislative findings. The legislature, the plaintiffs here had no control over what evidence was presented to the legislature. They didn't have an opportunity to cross-examine witnesses. A legislative hearing is something that helps inform legislators, but it by no means binds the court in how the court should determine an issue that is solely within the province of the court.
Thank you, counsel. Counsel, your rebuttal?
Your Honor, I'm not saying that the legislature's conclusion that this is not gambling gets deference. What I'm saying is that the question of the degree of skill versus chance is a factual question as to which the legislature held hearings and made findings. In this court, in the For the People or Theaters case, held that a substantial evidence standard applies to reviewing the factual finding of a legislative body. The plaintiffs could have appeared before the legislature and presented evidence. They didn't. And certainly in their summary judgment motion, they presented no evidence on the skill versus chance question. For every analogy he can draw to sports betting, I can draw an analogy to what general managers do.
But let me ask you this, counsel. If the presumptions at work in the legislative determination of what's skill versus chance are at odds with the drafters of the Constitution's ideas, do we then have to defer to what the legislature now decides? If it's fundamentally not grounded in the understanding of the drafters of the Constitution?
Well, I would agree with you, but I don't see how there's any fundamental conflict here. I mean, we do look to what the drafters of the constitutional amendment had in mind, and what they had in mind at the time was based upon, guess what, statutes that had been enacted historically by the legislature. I mean, on that point, we're really not in disagreement because those statutes all prescribe games of chance, wagers, and future contingent events, but skill-based competitions were always exempted from that. He tries to distinguish buying stocks with this policy argument. Well, who made that policy call? Who said that that makes a difference that you own something? The legislature did. That happened in the 80s, that they exempted insurance and commodities trading and the like from the definition of gambling. It was the legislature that did that, and that informed the understanding of what wasn't gambling when the 1894 amendment was enacted. So if this does come down to some, what's it more like in some fundamental way, as if you could do that with a made-up contest, I think that shows that it's a judgment call. And if it's a close question, tie goes to the legislature.
And if the test is not skill versus chance, then the legislative findings don't make any difference, right?
Well, yes, but I've yet to hear any articulable principle otherwise. I mean, no one has suggested, I mean, I recognize there are historical anomalies. Like you can say, well, why is this which seems to be skill-based, treated as gambling or not gambling?
Horse racing, for example, required a constitutional amendment, right?
Understood, but you don't ride the horse, but if you enter your horse into a horse race contest, that's a skill-based contest. I'm entering my fantasy team that I own, I assembled through skill, and I managed through skill, and I can beat you at that activity. And that's the relevant activity. And
But
since
you might assemble your trifecta as well, and that required a constitutional amendment.
That's right, but I don't
And
think
there's some skill there, right? I mean, there are people who make money at the track and people who lose money.
those types of bets are not structured in a competitive structure. And that, the structure is important because
Why do you say that? Because they're pari-mutuel, so they pay out based on the total volume of bets.
that's not the same thing as comparing how one person did at a particular activity versus how another person did at a skill-based activity. You're betting against the house. You just happen to be having this pooling system for determining the payouts, and that's a subtle distinction, but it's an important one. And the fact that it is structured as a competition defines the relevant activity, and it's that activity that you look to. And if I influence, I don't have to control the outcome of that activity. If I influence it, then it can rationally be viewed as a skill-based contest. And because it's not a sports betting contest, that would be, I think I said this before, that would be a tougher call because you actually are making predictions about how real-world sporting events are going to come out, and that presents policy considerations that I think aren't present with fantasy sport.
Thank you, counsel.
Thank you.